Good morning, good afternoon. It's Friday, and this is the Lunch and Learn on Powers of Attorney in Pennsylvania. Key things that you need to know. I'm Andrew Sykes, certified elder law attorney practicing in Pennsylvania, coming to you live from our conference room. So this session today, I'm really glad you joined us. We're going to cover the basics of what a power of attorney is and some practical tips on how to use it. And so if you're a Pennsylvania resident and you have a power of attorney, maybe you'll learn some more about it, how it works. If you don't have a power of attorney, I think this will be a good introduction to it. If you're a financial planner or in the financial industry and you're interested to know more about powers of attorney and things like how to judge whether a power of attorney that you're seeing is valid or not, I think this will be a good session for you. Or if you work in the, financial industry or some industry where you're looking at powers of attorney, and or even an attorney that doesn't practice estate planning all the time, I think this will be good to get you some basic rudimentary knowledge about it. Not going to go super deep, but as we have in the title, it's the key things that I think that you need to know. And also some, references to the statutes so you can find out more. All right, so with that, I'm going to get started with our presentation. All right, so here's our agenda: how powers of attorney work in Pennsylvania, why a power of attorney is important, and some practical tips. All right, so what is a power of attorney? So a power of attorney is a document that that a person can sign. That person's called the principal, and we'll go over some important terms in a minute. So the principal signs a power of attorney and can appoint an agent to carry things out under the terms of the power of attorney. So the power of attorney, or POA for short, defines the powers that the agent has to act in his or her behalf. And why are they important? Well, if you become incapacitated and can't manage your own affairs, your agent is able to act on your behalf and do things for you, like pay your bills, do your banking, sell property, manage all kinds of financial affairs. And it's important because it allows somebody to act for you immediately. So if you don't have a power of attorney, the state of Pennsylvania has a plan for you, and it's called guardianship, right? So somebody who's incapacitated can have a guardian appointed. So somebody would go before the local court of common pleas in the orphans court and file a petition and ask to be named this person's guardian. And if the judge finds the person is incapacitated, doesn't have mental capacity to manage their own affairs, then the judge can appoint a guardian, and the guardian acts for that person. But that comes with a lot of strings that you might not have anticipated. So things like it's the judge that's going to pick the guardian, not you. When you sign a power of attorney, you can pick your agent. If it's guardianship, then now you're under court supervised control. So if the guardian needs to, say, spend money out of principal to pay for your nursing home care, they've got to file a petition to get permission from the judge to spend principal for that reason. If they're going to pay their attorney for getting the guardianship established, got to file a petition for that. So guardianship is not ideal, and it's not immediate. Okay, it's going to take, unless it's an emergency, which they define very narrowly, usually going to have to wait 30 to 60 days before this whole process can play out in the court and somebody can be named guardian on your behalf. So it's a really important document to have, the power of attorney to have signed on your behalf, so that if something happens to you, somebody could start that day or whenever the power of attorney goes into effect, and to start doing things on your behalf and save you a lot of hassle, save your loved ones a hassle, and get you better security than you would without a power of attorney. And we'll talk more about why powers of attorney are important, especially to have one that's really tailor-made. All right, so some terms. The principal, this is the person on whose behalf the power of attorney is being made. So, in December when I updated my estate planning, I signed a new power of attorney. I'm the principal. All right, so I appointed an agent. All right, so this is the person that's going to act on my behalf. And in my case, that was my wife. So she's the agent. And it's also good practice to have a couple of backups, right? So what if my wife and I are in the same car accident? Well, she obviously, if she's incapacitated too, can't serve as my agent. So I do have a couple of backups. You might have heard the term durable, a durable power of attorney. So that simply means that if I become incapacitated, it remains in effect. Sort of an obvious thing. That's why you have it. But historically, powers of attorney, in many cases, were not durable. So if I might sign a power of attorney authorizing somebody to do some limited thing on my behalf, but if I lost capacity, then, if it's not durable, then it would no longer it would no longer be effective. So many state legislatures, including Pennsylvania, amended their statutes. I think in Pennsylvania it was in the early 80s to have durable powers of attorney. So today in Pennsylvania, powers of attorney are presumed to be durable unless you state otherwise. So that's a good thing. I see I'm having some technical problems with my camera. Let me see if I can fix that. I'll just hang on. I'll remain in audio contact. It might be a lighting issue, so we'll adjust the lighting. See if that helps. Maybe that does. Okay. So I was talking about durable power of attorney. So these days, pretty much across the country, powers of attorney are usually durable. But just so you understand, if you see general durable power of attorney, that's what that's referring to. Another important term is whether it's immediate or springing. So if you set it up so that it goes into effect immediately, then nobody has to do anything. If you become incapacitated, they can start acting on your behalf right away. So personally, that's how mine is set up. And I wanted to do that because I'm very comfortable having my wife be the agent, and I don't want her to have any kind of impediment to be able to act on my behalf if something comes up. Springing would mean that it doesn't go into effect immediately. It would only go into effect upon some event happening. So a typical way to set up a springing power of attorney would be to say, this power of attorney goes into effect only when I become incapacitated, as attested to in writing by maybe my attending physician, something like that. All right, so you may want to set things up that way. Maybe if you're younger, you don't have a spouse, you don't have somebody that you're really close to, and you're appointing somebody as an agent, but you want to make sure that they don't get a hold of that and try to do anything on your behalf before you want them to. All right, so then you might set it up so that it only goes into effect when a doctor is saying in writing that you're incapacitated, and until then, nobody else can use it. So you have to think about the practicalities of that. So in my case, I was comfortable having my wife be the immediate agent, and didn't want her to have that extra hassle of, tracking down a physician, and what if it happens on, I become incapacitated on a Friday afternoon, and maybe the doctor's away for the weekend or that sort of thing. So anyway, I didn't want any kind of impediments. I just wanted to go into effect immediately. So those are some things to think about. And if you're looking at powers of attorney, look for that. Is it in effect already? If you're being presented with it, or if it's a springing power of attorney and it requires some sort of written attestation, is the attestation with the power of attorney. All right, so the statute in Pennsylvania starts at this citation here, 20 PACS. So it's Pennsylvania Consolidated Statutes 5601 et seq, so meaning the statutes that follow that. So let me see if I can be helpful to you here and give you an idea of how you can look at that too. So give me a moment to see if I can bring that up for you. Going to see if I can pull up the internet citation here. What I did was I opened up a search engine browser and simply typed in 20 PACS 5601. And here are the results that I got. So the top one here is from legis.state.pa.us. This is the Pennsylvania General Assembly. So I'm going to click on the top result that I find there, and that should lead me right to this statute. And sure enough, it does. There's powers of attorney, courtesy of the Pennsylvania General Assembly, and you can see you've got all the powers of attorney statutes here, 5601 through 5614. So we can just kind of scroll through that. And it may be hard for you to see on your screen, especially if you're watching this on a mobile phone. So I won't ask you to read it, but 5601, we can see starts with the general rule, and then 5601B starts with execution. So there's a section here which I'll talk about execution and how you have to get things executed. I'm going to take a moment while I have this pulled up to just scroll down a little bit. If you can't read it, it's okay, but I just want to demonstrate that 5601, I believe it's C, has this notice requirement, right? So all powers of attorney in Pennsylvania have to have this language. And it says, notice, this power of attorney is to give the person you designate, your agent, broad powers to handle your property, which may include powers to sell or otherwise dispose of any real or personal property without advance notice to you or approval by you. So it gives the person signing the power of attorney notice about what it is that they're signing, and it talks about the duties they're giving their agent and the powers that they can give their agent and so on. So that's where you'd find the language currently as I'm giving this presentation in March of 2025. This is the current requirement for notice provisions. And then a little further down in D is an acknowledgement executed by the agent. So after you sign your power of attorney and sign the notice, then the agent, before it can go into effect, has to sign this form that says, I have read the attached power of attorney and am the person identified as the agent for the principal. And then they have to acknowledge that when they act as agent, they have to act within your reasonable expectations to the extent actually known by them and that sort of thing. So there's language that they have to sign as well. All right, so that's where you find the statute, and there's a lot of good information in there about how powers of attorney work in Pennsylvania. All right, so back to the presentation here. So that's the statute, and I'm going to give you the basics about execution. So again, this is current as of March of 2025. If you're watching this later on YouTube, we're broadcasting it live here, but if you're watching it later, it could change in the future. So, but currently, to be properly executed, a power of attorney needs to be dated, and then it needs to be signed by the principal. And the statute says that it can be signed by signature, which is how they're usually done, or by mark. So you might have a person who can't move their arm, right? They can't grip their hand anymore, but they can just make a mark. So a mark is good enough. Or maybe you can't sign at all. Maybe somebody has paralysis and they can't sign their power of attorney or even make a mark, somebody else can sign at their direction. So if it's signed by another person at the direction of the principal, that's valid too, as long as if you're making a mark or somebody else is signing, then you need two witnesses and a notarization. But actually, all powers of attorney in Pennsylvania need that notarization and two witnesses as well these days. So when it was first enacted, it just said, you needed two witnesses and a notary if it's signed at the direction of someone else, but now they all do. So there is some language in the power of attorney that you want to pay attention to. So things like if you're the person signing the power of attorney at the direction of the principal, you can't also be one of the witnesses. So I give you the citation down there on the slide, and it's 5601B, where you'd find the details about how it should be properly executed. And then the other requirements we talked about, notice. Okay, you have to have that notice provision, and you have to have the agent acknowledgement form. So that's how, these are the basics of powers of attorney in Pennsylvania in order to be valid. Well, what about older powers of attorney? Sometimes you might have a power of attorney that doesn't have that exact language in the notice provision. The notice provision's been around probably for, I'd say, 20 years, at least 20 years. But the language was different before 2014. So something that you might see a power of attorney that was signed in 2008 and would have different language. Okay, might still be valid. If it was valid at the time when the statute was changed, the new ones, the old ones were grandfathered in before the new language took effect. This requires probably a little bit of help from an attorney. If you're looking at an older one, you might have to consult somebody who knows how to research what the statutes were at the time that the power of attorney was signed. But you can't presume that just because it was signed 15, 20, 30 years ago, it's not valid. It may very well be valid if it was valid at the time and conformed to the current requirements that were in effect at that time. But that sometimes becomes an issue. So when you're looking at them, even if they're older, they still might be valid. Sometimes the third parties, the people that are being presented with the power of attorney, a bank, an insurance company, that sort of thing, they may request some sort of an affidavit. So the statute goes into more details about how that's requested and how an affidavit can be given. But essentially, the company wants to know, is the power of attorney still in effect? Is the principal still alive? Has the principal revoked it or not? All right, so it's common if something is 10 years old, the company, before accepting your power of attorney, may request an affidavit and make sure that whoever is presenting them with it has attested to the fact that it's still in effect and it's still valid. All right, now we're going to get to the real purpose of powers of attorney and come back to the importance of it. So powers of attorney are not all alike. It's not a one-size-fits-all kind of situation. And I say this as a certified elder law attorney who's been practicing elder law for over 20 years in Pennsylvania. They should really be tailored to the needs of the principal. All right, and again, coming back to why powers of attorney are important, I think powers of attorney are at least as important as your will or your trust, living trust, revocable or irrevocable living trust, because whatever the will is doing to distribute your assets or your trust, that you might have all these plans in place for what's going to happen after you're gone. You might not have anything left, depending on what's in your power of attorney. All right, so you want to set it up so that people can act on your behalf responsibly and in such a way so that they preserve your assets And you really have to pay attention to what's in the power of attorney, because these days, if things are not handled properly and not, if your power of attorney does not have the right provisions, there could be an issue as to whether or not you have any assets left to give anybody. So I'm going to be talking about 5601-4. So to be helpful to you again, let me take a minute to get out of this presentation and see if I can show you how to find that exact statute. All right, so before I showed you the statutes beginning at 5601, and I think I can show you this one too. 5601-4. Okay, so here I just Googled that exact one. So rather than having to scroll through the whole collection, it is possible to select the top result here. So I got this exact statute, 5601.4, authority that requires specific and general grant of authority. So this is a really important piece of the power of attorney provisions in Pennsylvania. And the first thing is it's going to talk about something that's colloquially termed the hot powers. These are powers that require a specific grant of authority. Okay, so in other words, it's common for a power of attorney to say something general, like my agent can do anything and everything that I would be able to do if personally present, something like that. So that's a general, broad grant of authority. But the attorney statute, power of attorney statute, requires that if you're going to do something like make a gift as an agent, you have to have specific authority to make a gift. A broad grant of authority to do anything and everything isn't going to authorize you as the agent to make a gift unless the agent has specific authority written in the power of attorney for that. So I'm not sure you can read this statute, and I'm expecting you to, but I'll just go through some of these. So the things like creating, amending, revoking, or terminating an inter vivos trust. So that's a living trust. I may have created a trust during my lifetime, a revocable trust, let's say. And if I want to have my agent have the ability to modify that or even revoke it later on, I would have to state that in my power of attorney. Another one is making a gift. So that's going to be important, and I'll talk about that more in a few minutes. Another one is creating or changing rights of survivorship. So that would be important. You know, if you own a piece of property and your will says everything goes to my 3 children equally, and somebody acting under your power of attorney change that to make it so that your oldest son is a joint owner with right of survivorship, and that's your main asset in your estate, that's going to dramatically change your estate planning, allow somebody else to, your son to get that entirely. So things like that can dramatically change your estate plan are those types of powers that need the express authority, and I think you can see why that would be. Another one is creating or changing a beneficiary designation. Same thing. If my beneficiary designation on my 401k says it goes to, all of my children equally, and, let's say it's somebody that has a couple $1 million. If somebody had the power to change the beneficiary designations, that could dramatically affect who gets what. Another one is waiving the principal's right to be a beneficiary of a joint and survivor annuity, including a survivor benefit under a retirement plan. So again, if you're married and your spouse has a retirement plan, like waiving that could dramatically affect what your income would be if your spouse dies. So that's another important point in a power of attorney that would require your express authorization if somebody's going to do that on your behalf using the power of attorney. Disclaiming property, so giving up the right to property. So all these, and this is not the whole list, but that's a sample of some of those hot powers that require express authority, and I think you can see why. All right, I'm going to go down further to talk more about gifts while I have this statute pulled up on the screen. Again, I'm not expecting you to be able to read it. I'm not sure that you can unless you're looking at it with a computer screen that has a pretty good monitor on it. But what it talks about is gifting. So are you authorizing your agent to make gifts of your property during your lifetime? All right. This is an important issue because these days people can live a long time being incapacitated. All right. So it's not all that unusual for somebody to be incapacitated for 5-10 years, something like that, with dementia, and require somebody else to act on their behalf. Now, during that time, maybe some things might have to be done. For example, if you had a federally taxable estate, maybe your agent, it would be prudent to make some gifts on your behalf in order to avoid federal estate tax. So that might be an example. Another very common one is if you are in a situation where if you're in a nursing home and you could qualify for Medicaid, if you could transfer some of your assets, that would be another situation where you might it might be beneficial for you to have gifting powers in your power of attorney, so that if you have a spouse, instead of your spouse having to spend down $12,000 a month for possibly years, your spouse could, or somebody, whoever your agent, could transfer funds to your spouse so that you could qualify more quickly and allow your spouse to be more financially secure in the future. Or maybe you have a disabled child, right? So the Medicaid provisions allow you to transfer funds to a disabled child, and there's no penalty for having done that. So I've seen situations like that where somebody was able to transfer, say, $300,000 to a disabled child to provide for them, and then qualified for benefits the next day and didn't have to spend that down. All right. So again, it's a very important provision to have if you're in that situation. Now, somebody else, gifting provisions might not be advisable. Somebody that has enough assets and income that they would never qualify for Medicaid, that they would be able to pay for nursing care out of income, perhaps, but they don't have any spouse or children, and maybe they're appointing, nieces or nephews as their agents. Might not be a good idea. That might open them up to exploitation if somebody had gifting provisions and was allowed to transfer gifts, make gifts and transfer property to somebody else. So that's why I'm coming back to that point about the importance of powers of attorney and why they really need to be tailored to someone's exact circumstances. Now, thankfully, the provision in the current power of attorney statute speaks to this. And it says if you use the term, making a gift of the principal's property, these guidelines in the statute as it is currently written say that authorizes your agent to make a gift that the agent determines is consistent with the principal's objectives if the agent knows those objectives. And if they don't know those objectives, it gives some guidelines. So they can make gifts if the agent determines it's consistent with the principal's best interest based on all relevant factors, including the value of the property, foreseeable obligations that the principal may have, minimization of taxes, eligibility for a benefit. So again, coming back to that nursing home example, if somebody might be eligible for a benefit and be able to protect assets for somebody else in their family, that would be consistent with the guidelines currently given in the statute. So 5601.4 is a very important provision to look at if you're in a situation where you might need to make some decisions about that. All right, so let me get back to the presentation. All right, so we talked about what the powers should be and the fact that they should be very tailored. We talked about the hot powers needing express authority, gifting powers. If you use the term limited gifts, that has a specific meaning. So in general, if you'd say my agent can make limited gifts, then your agent could do something like make a gift of somebody, you know, one of your children, up to the amount that the IRS says you can gift without filing a gift tax return. So currently that's $19,000 per person per calendar year. All right, so limited gifts has a specific meaning, which might be appropriate for some people. Again, going back to tailoring powers of attorney for the people to meet their particular needs. But in some cases, you know, limited gifts may be too limited. The example I gave about the person with $300,000 and a disabled child ending up in a nursing home, $19,000, that would, you know, if that were the limitation, you'd probably lose a lot of money before qualifying for benefits. So again, can't stress that enough. Powers of attorney should always be tailored. And the disclaimer provisions when you're disclaiming the right to some property, very similar to the gift provisions, you know, that it gives the factors that the agent can look at to determine whether the disclaimer would be proper. All right, so now we're going to talk about some practical tips. Keep your power of attorney somewhere safe but accessible. So I think you can see why that would be now. If you're in an accident at 3:30 on a Friday afternoon, it might be really good to have that available at home rather than in a safe deposit box, right? Because you know somebody might not be able to make it to the bank before the bank closes. The bank's closed, you know, at 4 o'clock on a Friday, let's say, and they're closed Saturday and Sunday, and maybe Monday's a holiday too. All right, so it could be days that would elapse if the power of attorney was kept in your safe deposit box. So I don't really recommend safe deposit box as the best place to keep it. It's certainly safe, but not necessarily accessible. So going back to my own example, when I updated all of my estate planning in December, put it in a binder and put it in a closet where we keep important items. And then I took a photo of that on my phone, and then a photo of the closet, and sent that to the people that would be my agents or successor agents, so we can make sure that they know where to find it. Going to the second point on this screen. And then logistically, you want to make sure that people can actually get to it. So does your agent have a key to your house? Or if you're keeping it in a fireproof safe, do they have a combination to the safe? So these are the most important things, is just the logistics of having it accessible, making sure people know where it is, and having them have logistical ability to get to your power of attorney and be able to be used by them. All right, so thanks for watching. I'm going to remain online here for a moment. I'll see if there are any questions. Let me just see if there are any comments that anyone has made. Okay, so if you're watching this on the live stream, if you have any questions, you can put those in the comments, and I'll see if anybody has any questions on that. In general, now that you know the statute and how to find that, it's really easy to get in there if you have some particular questions about things like, you know, how do I prove the validity of the power of attorney if that's an issue? You know, does the bank need to accept the power of attorney, and if so, under what circumstances? Or, you know, can they question it? Do they need a translation? So a lot of details about powers of attorney that you can find in that statute that I just don't have time and a lunch and learn to go into. So I'll leave that to you to delve into more if you want to get more information about that. I'm not seeing any questions or comments, so let me just thank you again for watching. And if you're watching this later on YouTube or some other platform, you can like and subscribe and be notified when we do live streams in the future. So thanks for your attention, and I'll see you next time.